भारत का संविधान हूँ।
जानिए अपने संविधान को।
I welcome you to today's edition of Know Your Constitution, a program to understand the various aspects of the Constitution of India. You're listening to us live on the YouTube channel News on Air Official. It's also available on other digital platforms. Today's topic is Directive Principles of State Policy. I am Pragya Deora, and we have with us Mr. Satya Prakash, the legal editor of Tribune, as our guest. Part 4 of the Indian Constitution deals with the Directive Principles of State Policy. Could you please explain to us what is this concept and what all does it entail?
Well, last time we discussed fundamental rights of the Constitution in Part 3. Fundamental rights are rights which are justiciable rights, which are rights against the state. A state cannot take it away. But there are certain positive rights which are called Directive Principles of State Policy. Positive rights means the rights which the state was in a position to give us directly at the time of coming into force of the Constitution. So they were given to us, and we can claim it as a matter of right. But the state was not in a position to give us so many other things, and if the Constitution makers had made it mandatory, it would have been difficult for the state to implement those things. So what the Constitution makers did was they put it in Part 4, where instead of giving us the right, they put an obligation on the state that the state shall do all these things. And there is a proper provision under the Constitution, Article 37 of the Constitution, which is understood to be the key to entire Part 4 of the Constitution. There are three parts of Article 37. First part says that the provisions in Part 4 of the Constitution, that is Directive Principles of the State Policy, shall not be justiciable. Means any citizen cannot go to the court and say that these rights must be, or these things, whatever provisions are there in the Part 4 of the Constitution, should be enforced and implemented. But at the same time, the Constitution maker said that provisions in Part 4 of the Constitution shall be nonetheless fundamental in the governance of the country. So this is how Part 4 of the Constitution becomes very important. These provisions are not justiciable, but still they are very much important, and they have to be implemented through laws, because they put an obligation on the state that the state shall implement these provisions while making laws. And this is how Part 4 of the Constitution is being implemented through various laws. And there is an entire history of laws being implemented, and laws which are based on Directive Principles of State Policy, various, say, cow protection laws, prohibition laws, or say right to free legal aid, and there are various other provisions which have been implemented. And nowadays we have talked about Uniform Civil Code, which is also there in the Part 4 of the Constitution, Article 44.
The idea of the Directive Principles was borrowed from the Irish Constitution. But how did India's social, economic and political context of that time have a bearing on the Directive Principles that were framed for our Constitution?
Well, Directive Principles of State Policy, as you have said, they were borrowed from Irish Constitution. In fact, much of our Constitution, the various provisions and parts, they are based on the constitutions elsewhere. Whatever best was available elsewhere in the world, we tried to incorporate those and tried to adopt those principles and provisions in accordance with our needs. And this is how Part 4 of the Constitution, particularly this Directive Principle, came to be part of our Constitution. But India was not Ireland. We had a completely different socio-economic and rest of the conditions. So what we did was, in a way, if you see the entire Directive Principles from Article 36 to 51, 36 is nothing but it talks about a state, and 37 I have already explained to you, but 38 to 51 there are various provisions broadly we can categorize them into three parts. One is the parts which deal with socialist principles. The second, which deal with Gandhian principles, and third, which deal with say you can say that scientific temper, generating scientific temper in the society, so that people get rid of their beliefs which are not in tune with the scientific temper. So these are three parts, and accordingly we have incorporated. So it is not the verbatim incorporation of or adoption of what was there in Ireland. We tried to incorporate certain provisions in tune with our needs. And if you recollect, not just that, we have amended the Constitution several times. We also amended Part 4 of the Constitution. And 42nd Constitutional Amendment, it added certain things. It added Article 39A regarding free legal aid. It added Article 48A regarding environment protection. And both these provisions went on to become separate laws. The Parliament chose to enact separate laws for enforcement of these directive principles. So the idea that we chose to have directive principles, and why? Because at the time of the Constitution, adopting the Constitution, we did not have that much resources to ensure that all these things, which as a newborn nation we wanted to give it to our citizens, it was not feasible that time because of the dearth of resources. But with the passage of time, we have many of the provisions have been shifted to even at least right to education, which were there in Article 45, right to education for children between the age of 6 and 45. It is part of Part 3 of the Constitution via 86th Amendment. So, and now we have fundamental. It has become a fundamental right. So the idea that we don't have that much resource, which was there in 1950, with the passage of time, as and when we have resources, we have implemented Part 4 provisions, and some of them have been shifted to Part 3 also, that is fundamental rights chapter. So if you see the journey of the implementation of Part 4 of the Constitution, it's a fascinating journey. Fascinating in the sense that some of them have been translated into the fundamental rights, and many of them have been given effect to via various laws, which is the mandate under Article 37 of the Constitution. As I mentioned to you, the Prohibition Laws, the Cow Protection Laws, the Environment Protection Act, the NALSA Act. So these are the laws which have been enacted, and through these we are trying to implement the Part 4 of the Constitution.
Also, we do see the influence of the ideas of Mahatma Gandhi in our directive principles through panchayats and cottage industries. So we do have that Indian aspect to our directive principles.
Well, as you mentioned about panchayats, we all know that Article 40 talks about panchayats. But even that has been given effect to. Article 73rd Constitutional Amendment, the devolution of power, the Tier 3 of the government. Much of power has been given to the panchayats, and they have been given a proper constitutional status. And not just though the Constitution talks about panchayats, the rural local bodies, even urban local bodies, they have been given that status. So this devolution of powers at the grassroots level, which was the Gandhian idea, that all the power should not be concentrated in the center or the states. People should be deciding the local issues as per their own needs and understanding. Even that has been given effect to with the implementation of the 73rd Amendment in 1992. So it's quite fascinating to see the Constitution and Part 4 in particular getting translated on the ground via various laws. As I mentioned to you in the beginning, Article 37 is key to implementation of the entire Part 4, because 37 talks about it says it is non-justiciable, but still it's fundamental in the governance of the country, and there is a mandate or there is an obligation on put on the state that state shall implement Part 4 of the Constitution through enactment of various laws.
You were mentioning about fundamental rights and the directive principles. So what is the relation between the two? How similar and different are they from each other? And also, what has been the conflict between the two, and how has it been resolved over the years? And where do we stand today?
Well, fundamental rights are known as negative rights. You can negative rights because there is an obligation put on the state that state shall not take it away. If you read the most important fundamental right, Article 21, that is right to life, it reads like no person shall be deprived of his right to life and liberty except according to procedure established by law. So there is a limitation placed on the law, placed on the state. But if you look at the entire Part 4 is not that state shall not do this. Part 4 is that there is an obligation put on the state to do certain things, and so Part 4 is known as positive rights. Interestingly, when certain questions arose and some conflicts were there between Part 3 and Part 4 provisions, initially, particularly in the 1950s and early 60s, the Supreme Court chose to interpret as if Part 4 is subordinate to Part 3. That is, directive principles are subordinate to fundamental rights. But as the law evolved and the various other cases went to the court, in the 1960s they started interpreting it as and saying that there should be harmonious construction between the two. The both should be harmonized and one cannot be seen against the other. And this is how the law evolved. But then finally, in 1973, in Keswanand Bharti case, the famous case in which the concept of basic structure came into being, and that placed additional limitations on powers of Parliament to so far as their power to amend the Constitution is concerned. But that apart, what is important for this discussion is the Supreme Court. In Keswanand Bharti case, the Supreme Court said directive principles should be understood or should be interpreted as a sort of reasonable restriction on fundamental rights. And why? Because they said fundamental rights are guaranteed to individuals, and directive principles are broadly talk about the broader aspects and the community and the nation, the larger perspective. So what the court said, that the community and the national interest cannot be subject to individual rights. So in a way, they said directive principles should be understood and interpreted as reasonable restrictions on Part 3 of the Constitution, that is fundamental rights. And since then, the Supreme Court and most of the constitutional courts, they have tried to harmonize the two, and the earlier understanding that one can be subjected to the other, that is gone, and now the understanding is that directive principles are important and they are not subordinate to Part 3 of the Constitution, that is fundamental rights.
You are listening to the program Know Your Constitution. You can listen to us on the YouTube channel News on Air Official and other digital platforms. Welcome again to the program Know Your Constitution. You're listening to us live on the YouTube channel News on Air Official. We're also available on other digital platforms. Today, we are discussing the directive principles of state policy. I am Pragya Deora, and we have with us Mr. Satya Prakash, the legal editor of Tribune. So you were mentioning that the directive principles are non-justiciable. However, they are used by the courts. They are useful in understanding and to see the constitutional validity of various laws.
Yeah, what I said was as per Keswanand Bharti case, the Supreme Court has said that directive principles can be interpreted as a reasonable restriction on fundamental rights, because the court came to the conclusion that this part, that is Part 4, is not subordinate to Part 3. And look at the provisions which are there in Part 4. See, as I mentioned to you, there are three broad categorizations. One is socialist principles. The second is Gandhian principles. Third is, provisions which talk about building scientific temper and intellectual, capabilities. Article 38 talks about promoting welfare of the people by securing social order through justice, social, economic and political, and to minimize inequalities in income, status, facilities and opportunities. In a way, this provision, Article 38, is in Part 4. But look at the things it is talking about. Securing social order through justice, social, economic and political. If you look at it, it is there in preamble of the Constitution. Preamble means the objectives set out for achieving the goals of the Constitution. So, and then it further talks about minimizing inequalities in income, status, facilities and opportunities. So, if you want to minimize inequality, right to equality, you are moving towards right to equality, which is there in Part 3, Article 14. So, the initial understanding of the Supreme Court that Part 4 of the Constitution can be subjected to Part 3, that is, directive principles are inferior to fundamental rights, it's gone. Why? Because if you analyze the provisions, they are not actually inferior to Part 3. Because here also they are talking about goals set out in the preamble, Article 38 I am talking about, and also they are talking about minimizing inequality, means you are moving towards achieving equality, which is the goal of Article 14. So the initial understanding was, they realized that initial understanding was wrong, and this is how finally they, in Keswan and Bharti case, they said both one cannot be subjected to the other, which was there in Golaknath also, but finally they said directive principles have to be understood as a sort of reasonable restriction on fundamental rights. And this is how, look at other provisions, say Article 39, to secure a right to adequate means of livelihood for all citizens, equitable distribution of material resources, again right to equality, prevention of concentration of wealth and means of production, equal pay for equal work for men and women, right to equality, preservation of the health and strength of workers and children against forcible abuse. This will be covered under Article 21. Right to life and liberty, opportunities for the healthy development of children. This is again, it can be understood, or it can be read into Article 21, which is right to life. So the broad categorization which the Constitution makers did, Part 3 and Part 4, it was primarily on the basis of the fact that the Indian state, a newborn nation state, did not have that much resources to provide everything to citizens to start with. So what they did was, they said certain things we are providing, come what may, and certain other things the state shall provide, and the only thing is that citizens cannot claim as a matter of right. So this distinction was initially made, and if you look at the evolution of law on the subject, in 1993, Unni Krishnan case, much before the 86th Amendment, or much before the Right to Education Act, in the Unni Krishnan case, the Supreme Court declared right to education a fundamental right way back in 1993. On the basis of what? They said initially the state did not have that much resources, but several decades after having implemented the Constitution, now the state does have that much resource. So the court said no, it is a fundamental right, and the state must provide free education, and compulsory education to children between the age of 6 and 14. And later on, 86th Amendment came, and then right to education came, and now we are implementing right to education. So the distinction which was initially understood, actually, theoretically there was no distinction. The Constitution makers, their intention was to give all these things to the citizens. The only thing was the resources and maybe some other constraints, and accordingly they tried to devise this, but the key was an obligation put on the state that you shall do it through laws.
This takes me to the next question. How far, in your opinion, how far have we been able to achieve what was laid down in the directive principles?
Well, it's a wonderful question because if you look at the journey of the directive principles over the decades, 50s, 60s, 70s, 80s, and now we are in the first decade of the new millennium, there have been several laws which have been implemented to give effect to the Part 4 of the Constitution. In the 1960s, there are several states which enacted cow protection laws. And as I mentioned to you, there are some Gandhian principles in directive principles, and cow protection laws are part of the Gandhian principles. And Article 48 of the Constitution says, the state shall endeavour to organize agriculture and animal husbandry on modern and scientific lines, and shall, in particular, take steps for preserving and improving the breeds and prohibiting the slaughter of cows and calves and other milch and draught cattle. So this was one of the Gandhian principles which was incorporated in the Constitution. And in 1960s, several states enacted laws to give effect to this, and they enacted laws to ban cow slaughter. And many of these states, cow slaughter, in fact, most of these states, cow slaughter is banned. So the laws banning cow slaughter, they get sustenance from the basis for them, the constitutional basis for them is Article 48. So if somebody challenges that, the Supreme Court will say, no, this is based on directive principles of state policy, which are not inferior to Part 3 of the Constitution. So this is very much important. Another example, see, prohibition laws. Many of these states, they have complete prohibition, be it Gujarat, be it Bihar, and many other states, they have implemented prohibition laws. And there is complete sale and consumption of liquor. Again, if you look at that, Article 47 of the Constitution, the states shall regard the raising of the level of nutrition and standards of living of its people and improvement of public health as among its primary duties, and in particular the state shall endeavour to bring about prohibition of the consumption, except for medicinal purposes, of intoxicating drinks and drugs which are injurious to health. So again, this is one of the Gandhian principles which the Constitution makers chose to incorporate as part of the Part 4 of the Constitution. But then, while implementing it, many of these states, they have enacted prohibition laws, be it Bihar, be it Gujarat. In fact, right from the beginning, there is prohibition, and we can talk about how effective they are. That's a different thing. But the fact is, there are laws which have been enacted by states to implement Part 4 of the Constitution. Similarly, this law on Panchayati Raj, we talked about 73rd Amendment, it has been implemented, and now the best part is in many of these states, not just Panchayati Raj system has been implemented after the enactment of 73rd Amendment. Also, women empowerment is happening through panchayats. Many of these states, they have reserved 50% seats for women in panchayats. So a whole lot of changes, social changes are taking place. Empowerment is taking place at the grassroots level, and this is via Part 4 of the Constitution. So if you ask me, I'll say Part 4 is equally important or no less important than Part 3 of the Constitution. This is very important. Similarly, there was 42nd Amendment, which is termed as mini constitution, but there are some of the provisions. Say even Part 4 was amended. 39A was added regarding free legal aid. 48A was added regarding environment protection. Both these provisions have been given effect to because National Legal Services Authority Act 1987 and Environment Protection Act 1986. Via these two laws, we are implementing Article 39A and Article 48A. So this entire journey of directive principles of state policy, various decades, we are implementing various provisions, but the most contentious provision of the directive principles of state policy, that is Article 44, the Uniform Civil Code, and that is yet to come, and there are a whole lot of debate about that. There was a couple of years back, there was a consultation paper released by the Law Commission of India. They said something, they talked about preserving diversity. But this particular government is talking about implementation of UCC. And in the last 2-3 decades, the Supreme Court has reminded the government of its obligation under Part 4 of the Constitution, and that they must implement Uniform Civil Code. This is coming from the Supreme Court, and that is interesting. And so far, I'm not talking about the present dispensation, but generally the government has chosen to shy away, and the Supreme Court has been reminding the government of its obligation under Article 44 of the Constitution. There are a couple of things which we need to understand. One is, nobody is saying that diversity should not be there. Uniform Civil Code can be implemented in two parts. First part can be that you ensure diversity of religious and cultural practices. Muslim can go for nikah, a Hindu can go for saptapadi, or a Christian can go for church marriage, or a Sikh can go for Anand Karaj. So far as religious and cultural ceremonies are concerned, rites and rituals are concerned, these states should not get into that. Let every community or members of every community get into the relationship of marriage as per their own rites and rituals and religious ceremonies. That should be left to the community concerned. But then once a marriage is solemnized, then thereafter the marriage must be necessarily registered, and then once the marriage is registered, the rights and obligations of husband and wife, irrespective of their religion, should be the same. So once you divide it in two parts, first part is ensuring diversity of religious and cultural practices, and second part ensuring equality, that irrespective of the religion of the party is concerned, once the marriage is solemnized, somebody is Hindu or Muslim, wouldn't matter, and each one of them will have the same rights and obligations.
When we're talking of the directive principles, we have seen that there has been certain criticisms which say that there have been different ideologies that we see within the directive principles, ranging from it being influenced from Gandhi to liberal principles to socialist principles, and it covers the various dimensions, various topics in terms of nutrition, health, protection of environment, monuments, right to work, and so on. How justified do you think are these criticisms?
Well, criticism we must always welcome criticism. This is the best part of democracy, that we always criticize each other, and in the process, best possible things come out. Because criticism, it will help us, dissect things, and then whatever is not necessary, in the process will get left behind. And the best of the things would be only get implemented. So criticism part should be welcomed. But so far as the basic criticism is concerned, like Part 4 has not been that controversial. So far as be it prohibition, be it environment protection, be it free legal aid, be it panchayat, these are all non-controversial issues. The controversy has been around certain issues, say cow protection and Uniform Civil Code, and this is because of the misunderstanding of the provision, and in particular because cow protection laws were implemented, they came into being mostly in 1960s, and that too when the Congress was ruling the country. So it has nothing to do with this ideology or that ideology. It's primarily about the Constitution.
Today we discussed about the directive principles of state policy. We understood what is the concept and how it has evolved over time, how it is in relation with fundamental rights, and how far has it been implemented on the ground. With this, we come to the end of this show. You were listening to the program Know Your Constitution. You can hear us on the YouTube channel News on Air Official and on our website www.newsonair.com. Thank you.
मैं भारत का संविधान हूँ।
जानिए अपने संविधान को।